Both sides?
And now judgment in the matter of Milton Keynes Hospital NHS Foundation Trust and the Commissioner for Her Majesty Virginia Judgment.
For the reasons given in the written judgments which I now hand down, we have decided that HMRC are entitled to raise an assessment under section 73 subsection 2 of the Value Added Tax Act 1994 on Milton Keynes Hospital's NHS Foundation Trust, claiming repayment of the amounts wrongly refunded to the trust under section 41 of that act. In consequence, the appeal will be dismissed and the appellant will pay the respondent's cost of the appeal to be subject to detailed assessment if not agreed.
Appeal in the matter of the test claimant in the Royal Mail Group Litigation and the Royal Mail Group Ltd.
Yes, Mr. Howard.
Good morning, my lord, my lady. Can I just say what a pleasure it is not to have to press the unmute button before I address the or indeed forget to do so. Where I'd got to yesterday afternoon, I just reached ZipFit and
yes.
the judge's treatment of ZipFit, and that is dealt with at paragraphs 89 to 90, 88 to 91 of the judgment. I'm not going to go through the detail of those paragraphs, which you're already well familiar with, but you can see at paragraph 88 he introduces 87 he introduces ZipFit and notes that there is an argument as to how far it goes. 88 whether ZipFit goes that far as Mr. Cordaro was submitting is a matter of serious dispute in that case, and he was saying effectively the effect of the Court of Appeal's decision in ZipFit is to stultify the administrative discretion to accept alternatives.
You must have an invoice.
You must have an invoice. Well, effectively you're thrown back on that because the administrative discretion route is blocked, because unless you can prove that the VAT has been paid and you won't have that in your hands as a commercial trader, what's happened up the chain, you can't use it. He says that's the consequence of it, and therefore the administrative discretion is blocked, and therefore, I suppose reasoning backwards to Parliament, assuming they knew what the interpretation was going to be in ZipFit, there is no alternative means of making your claim to input tax without a VAT invoice. That means the VAT invoice is central, and that helps his case on making it an actionable statutory duty. So that's, I think, his chain of reasoning. It does involve jumping back to Parliament, but in the sense that the court has declared what the administrative route means. Now, the judge considers that submission and analyses it. He quotes extensively from it, paragraph 89, and then at paragraph 91 reaches his conclusion. He does not consider that Lord Justice Henderson was going that far, effectively, as to stultify the section. He was delivering his judgment in a striking case in which he was actually apparent the output tax had not been paid. I interpose that itself distinguishes this case from most cases of which Mr. Cordaro was saying that the person seeking input tax would have a problem, which would be when they didn't know. They said, well, how can I know? This was a very rare case where they actually did know that it wasn't paid. That was highly likely to be the case, if not inevitable, where both parties treated the suppliers as exempt throughout. The supplier didn't change its mind, and express finding paragraph 116 of his judgment. His judgment focuses mainly on the invoice as evidence of payment and accounting, and the effect of the absence of that evidence. He acknowledges the offence to fiscal justice if the situation would generate a claim to input tax where the output tax had plainly not been paid in those exceptional circumstances. His reference to the need for evidence of payment of output tax by the supplier is made in that context. That's an important sentence. He's saying he was not generally, Lord Justice Henderson and the Court of Appeal was not generally saying, sorry, you can't use this discretion unless you've got evidence. In my view, what he is saying is that where it is plain that originally the supplier did not account for output tax because no one thought it was payable, then HMRC was not obliged to accept some form of alternative evidence based on a recharacterization of the transaction, unless it also produced evidence that the situation had changed and that the tax had in fact been paid, which I interpolate, of course, it hadn't been. He was not laying down a general rule applicable to all circumstances in which an alternative case was sought to be made. Now, Lord, we say that is all absolutely right. Can I make a few points on the strength of that? Well, the most important one is what the claimants must show on the basis of ZipFit, even to make their submission as a starting point. What they must show is that they were wrongly stopped from claiming. Sorry, can I start that again? What they must show is not merely that they were wrongly stopped from claiming without an invoice in their case. In other words, it's not enough for them to say, well, ZipFit's wrong, we shouldn't have been stopped. And after all, we acknowledge the case is moot, it's gone to the Supreme Court and it's now being referred to Europe. It doesn't help them to argue that or to say that the case is wrong. What they have to show is that the effect of it is to disable the discretionary route generally from protecting the interests of taxable persons lacking a VAT invoice. And therefore, that Parliament cannot be inferred to have considered it to be a satisfactory alternative to an actionable duty. That is, because this is all in the framework of is there an actionable duty, they would have to go that far on the strength of ZipFit to be able to really make use of, to block off the administrative route. Yeah. We say that is completely impossible on the basis of the judgment.
I mean, I did notice, I reread ZipFit overnight, and I did notice that paragraphs 86 to 88, Lord Justice Henderson did stress the right to deduct, and he said that, particularly 88, it wouldn't matter that Royal Mail had never accounted for output tax to HMRC because the right of deduction is a fundamental feature. So what he said about the invoice has to be seen in that context.
Indeed, it does.
And that's the point that Mr. Justice Mann goes on to make in 92.
It is.
Yes. Of course, I mean, the classic case may be the case where a taxable supplier is in, shall we say, a disorganized state because of financial problems, and perhaps does collect input tax but doesn't pay it over to the, does charge tax but doesn't pay it over to the customs because of insolvency. Now, in that case, there may be that invoice may have been issued because that's quite a simple exercise which isn't really bear on its financial viability, but it may be that they didn't.
Well, yes. Well, I certainly accept that, and there's nothing in the reasoning in ZipFit which touches such a case. And further to the passage that my Lord Justice Lewison has identified, to the same effect in paragraph 113. I don't know whether your Lordship have it open in tab 2. Mm-hmm. But what one sees there, dealing with objections from Mr. Thomas for ZipFit. Mr. Thomas argues that none of this matters because ZipFit was entitled to exercise its right to deduct and so on and so forth, to deny a deduction over the page on the sole basis that Royal Mail cannot be shown to have paid tax on the relevant supplies which made it to ZipFit, he submits to rely on a wholly irrelevant consideration because it would offend the well-established principle of the right to deduction is unaffected, etc. And then the response to that is not that's wrong. It's, in my view, however, this objection misses the point. And the reason he's saying misses the point rather than wrong is he goes on to explain that his holding is much narrower than that. It's not that merely that Royal Mail can't be shown to have paid tax on the supplies. It is because of the particular considerations to this case leading to the offensiveness to fiscal justice.
I mean, there is one might think a slight tension between the last part of paragraph 113, where Justice Henderson's last penultimate sentence, he says ZipFit's unable to produce invoices and is also unable to produce any supplementary evidence showing payment of the relevant tax by Royal Mail.
Why should it?
Yes.
So that there is a slight tension between that and what he said at 86 to 88, i.e. it doesn't matter whether Royal Mail paid or not.
I accept that, but that's why it's important then to read on to what comes in the next few paragraphs, because in my submission, what follows in paragraphs 114, 115, and particularly 116 elucidates what he was driving at by saying Zipfit is unable to produce invoices. What he's saying is, it can't. The point is not that they couldn't do so. The point is the facts. Why they couldn't produce them. They couldn't produce them because everyone knew the tax hadn't been paid, because everyone had understood the position to be completely different from what it was, and Zipfit certainly weren't offering any corrective action such as paying their own, correcting things down the line, as it were. And that is why he thinks it would be offensive to the sense of fiscal justice. And so, while I accept that read on its own, those last lines of 113 there appears to be some tension to the earlier passage. Read as a whole, the judgment, Mr. Justice Mann absolutely got it right in his interpretation of the judgment overall. So we say that the interpretation which is sought to be placed by the appellant is simply an impossible one. The discretion of HMRC to accept alternative evidence is there in black and white, and is protected by a right of appeal to the VAT tribunal and indeed all the way up to the Supreme Court.
Well, as I said to you yesterday, I'm not entirely sure it's a discretion.
Well, it's a discretion that may only be exercisable one way in certain circumstances.
If HMRC have the necessary information, then they must allow it. As I read the European case.
Well, my next port of call was going to be Vadan, which precisely makes that point, and maybe I can deal with that very shortly. My next submission was going to be, if Zipfit were to be given the construction for which my learned friend contends, then it would be contrary to European authority. It couldn't be right, and obviously that's not what Lord Justice Henderson was saying, because it would be directly contrary to Vadan and the European cases, which Mr. Justice Mann cites in his judgment a few paragraphs further in support of it's the very same paragraph 92. So one sees that Vadan was a case where the tax authorities refused to grant an applicant the right to deduct input tax because he was unable to provide invoices relating to his input goods and services. So precisely the situation, sorry, you haven't got the invoices. And the European court said that was no good, and the holding is quoted by Mr. Justice Mann at 41 and 42. The court has held that the fundamental principle of the neutrality of VAT requires deduction of input tax to be allowed if the substantive requirements are satisfied, even if the taxable person has failed to comply with some formal conditions. Now, obviously, formal conditions include VAT invoices. Follows the tax authorities cannot refuse the right to deduct VAT on the sole ground that an invoice doesn't satisfy the conditions required by Articles 226 and 7, if they have available all the information to ascertain whether the substantive conditions for that right are satisfied. Thus, the strict application of the substantive requirements to produce invoices would conflict with the principles of neutrality and proportionality, inasmuch as it would be disproportionately prevent the taxable person from benefiting from fiscal neutrality relating to his transactions. And so that, on the basis of that, I accept my Lord's point that the discretion, whether there's no discretion or whether there's a discretion that can only be exercised in one way, is semantic. But your Lordship is absolutely right, and it cannot therefore be even if it were, even if the interpretation of Zipfit for which my learned friend contends were the correct one, it wouldn't stand with European authorities, and therefore still wouldn't create a block on the administrative route, and therefore, with slightly artificial reasoning back, Parliament could not be intended to have thought that the administrative route was not a just and all-encompassing alternative, such that an actionable statutory duty was needed. So we say there's nothing in the appellant's submissions copiously sprinkled over his skeleton that the exercise of the discretion either was not a proper alternative or was haphazard, an uncertain avenue, or an action of statutory duty was required to avoid the malfunctioning of that system. None of that can stand with the proper interpretation of Zipfit and with Vadan and with the fact that this is judicially supervised discretion, which indeed will only be exercisable in the taxpayer's favour in an appropriate case where we're supported by the principles of fiscal neutrality and proportionality. My last indication, which I wanted to very briefly take the court to, was the point that the purpose of a VAT invoice is to ensure adequate supervision by the tax authority. It is part of a broader administrative scheme and is not the sort of protection of a limited class of limited class, such as taxable persons, which of course itself is hardly a limited class. It's an extremely wide class but in any event, it's not imposed for the protection of such a limited class, let alone can it be shown that Parliament intended them to have a private law right of action to echo the Exon Bedfordshire test. It is in truth clear that the primary purpose of a VAT invoice is part of a general administrative function imposed on HMRC, involving the exercise of an administrative discretion to supervise the VAT system and to ensure the repayment of input tax in appropriate cases. It's part of that process. Can I, this might be a convenient moment for me to hand up the empowering provisions of the legislation which I promised yesterday. If I think my junior has copies for the court. So what one can see on the first document is a formidable list. The Customs and Commissioners of Customs and Excise, in exercise of its powers conferred on them by, and then a long list of sections, and then for good measure at the end, and all other powers enabling them in that behalf, hereby make the following regulations. Now, my lords, my lady, we've done some, people behind me have done some assiduous research overnight and identified what we think looks like the particular power from that long list which would meet regulate the power to make the regulations in relation to VAT invoices. And that is to be found in Schedule 11 to the Act. Paragraph, it's the first page of the second handed up extract. Paragraph 11.1 and sorry, Schedule 11, paragraphs 2.1 and 2.2. And you can see in 2.1, regulations under this paragraph may require the keeping of accounts and making of returns in such form and manner as may be specified in the regulations, may require taxable persons supplying goods and services in such cases, persons of such descriptions, as may be so specified, to provide the person supplied with invoices, to be known as VAT invoices, containing statements of such particulars as may be so specified in the supply. If the person buying whom the goods or services supplied, containing such an indication, may be required by the regulations of whether VAT is chargeable on the supply under this Act or the law of another member state, and such particulars of any VAT which is so chargeable as may be so specified. And then further provisions about the regulations, what may be included in the regulations in section 2. So that appears to be an empowering provision scheduled to the Act, which permits the making of all the regulations which have been made. My lords, my lady, we would say that there is absolutely nothing in that empowerment section which gives any positive indication whatsoever that what Parliament was intending to confer was a right on HMRC to create an actionable private duty in respect of that duty to provide a VAT invoice. this is part of the overall administrative mechanism born out of the directive and created pursuant to that to ensure proper supervision of the VAT system and to ensure the principles of VAT accounting are properly carried out in accordance with principles of proportionality, fiscal neutrality, and so on that one sees recited in the VAT Act. And the VAT invoice is simply part of that mechanism. Of course, it's extremely useful for a trader in an ordinary case, and none of my submissions are meant to say it doesn't matter to the trader whether or not they get it. But ultimately, the regime which is set up includes provision for VAT invoices, which assists HMRC primarily in supervising the system and ensuring that things are being properly passed through, but also includes the administrative discretion, which is integral to allowing taxable traders to reclaim where, for whatever reason, deliberate or accidental, or for whatever reason, that the invoicing system has not worked. And also, of course, includes the penalties on traders if they don't produce VAT invoices to be a spur to them to actually keep up to the mark. And so we do say that that is relevant because it really goes back to the point in X and Bedfordshire and Hague that we looked at right at the beginning. The point being made that where one is really dealing with a general administrative function of that time, that is a very strong indicator against a actionable duty. This is not a narrow protection of a limited class needing, which can only be answered by them being able to take up the cudgels and enforce the duty directly. This is selecting one part of a larger administrative scheme supervised by effectively a regulator, HMRC, to ensure the smooth running of the system.
And presumably, Mr. Herberg, you'd also say that the inclusion of a penalty for failure is part of and chimes perfectly with the fact that this is an administrative system.
Indeed, precisely, my lady. And the fact that the penalty isn't all that big is really not to the point.
Well, it may be for some traders.
Well, they're quite large for some traders. Given the number of invoices there must be in this case, the penalty could be absolutely massive. But it's clearly not a vast penalty. But the point is, you have my submission that in any event, no trader wants to attract the attention of the commissioners for having effectively a system that not complying with their obligations and for effectively potentially having a system that isn't working. It is part of a spur, and the way it's dealt with by HMRC in their manual bears that out completely.
But its very existence is consistent with the administrative process.
Indeed, my lady. And one sees that same view being taken of the VAT system, of it being part of an administrative system in two European cases, which I'm not going to take you to, but maybe I can just deal with them from my skeleton. And indeed, I need to, because the skeleton goes a little bit wrong at this point. It's paragraph 63 of my skeleton in tab 7 of the core bundle.
63.
63, my lord.
No,
that's
my
not
tab 7
I've
stops
made a
at
mistake. Yes,
37.
I'm on to continuing duty already. I'm in the wrong skeleton. Tab 6, I apologise. Page 64 of the bundle. There's a word processing error here in paragraph 63. It appears that the whole of that quote comes from Petroma and Belgium. It doesn't. The first two paragraphs.
Sorry, hang on, I'm a bit lost.
I apologise. This is a page.
Page
64.
Page 63.
Starts on. It's page 63 to 64, and it's also paragraph 63. It's in tab 6.
Yeah.
You'll see in paragraph 62, I've introduced the same point, the purpose of the VAT invoice. And then 63, I rely on European case Petroma. Now, the first two paragraphs of that case, that is a word processing error, are not from Petroma. They are from Barlis, which you will see is actually cited at the end of the second paragraph of the quote.
Yes.
Those are paragraphs 27 and 30 from Barlis. And then to similar effect, Petroma is the next two paragraphs of the quote, which is paragraphs 27 and 28 of Petroma. Barlis is in the bundle, just for your lordships and ladyships note, bundle 7, which is a bundle that we've hardly visited, and Milan Friends Additional Authorities, tab 27. And Petroma is bundle 4, tab 11. Royal Mail, I'm not going to take you to the cases themselves unless you wish, but one can see there the court saying in Barlis the objective of the details which must be shown in an invoice is to allow the tax authorities, so it's for the purpose of the tax authorities, to allow the tax authorities to monitor payment of the tax due and, if appropriate, the existence of the right to deduct that. Therefore, in the light of that objective, that it should be examined whether invoices such as those at issue in the main proceedings comply with the requirements.
So this passage should have read, see first of all Barlis, paragraphs 27 and 30, which you quote, and see also Petroma, paragraphs 27 and 28, which you then quote.
Oh, yes, precisely. I apologise.
Yeah. I did notice, though, that in one of the additional authorities that came in, it's the Société Générale de Grande Source d'Eau, which is in our bundle 8, tab 4. The Advocate General, discussing the function of the invoices, does seem to think that protecting the right of deduction was part of the purpose of the invoices, though I'm not at all sure the court took that view. I think it was that case.
I'm just looking for the passage, which I've not.
987, I think. Report paid.
Yes, that's the sideline passage, yes.
I think it's paragraphs 12 to 14 of the Advocate General, and in particular 14. The regime is based on two fundamental principles and objectives. First, levying taxes and the combating of tax evasion, and secondly, safeguarding the right of taxable persons to deduct input tax.
Well, that is an absolutely uncontroversial statement about the purposes of the tax regime.
Yeah.
It is clearly the objective of safeguarding the right of taxable persons to deduct income tax, principle of fiscal neutrality, and that is what Vadin is of course also referring to. But my point is that can be protected in a number of different ways, and it is not true that the only way it is protected is by the provision of tax of VAT invoices. That's obviously part of the way the system functions, and of course it's important in the ordinary course of events for someone to have their VAT invoice. But the safeguarding of the right of taxable persons to deduct income tax is achieved by the rules as to VAT invoices, but also by the administrative discretion of the revenue to accept evidence other than invoices, and by the way that discretion is judicially supervised and understood, which, as I've already submitted, significantly downgrades the importance of VAT invoices because one can get to the right place by another route. So certainly in that passage, I would suggest that the Advocate General's remarks are unobjectionable, and indeed are absolutely right to that effect. What one doesn't see, I don't think, is a statement that it is the VAT invoice and the VAT invoice alone which is essential to the operation of the system. If there was something...
I see that nothing in the judgment has been sidelined, so presumably nothing is...
I don't think the court... The court seems to have decided it's on much narrower grounds.
Indeed. So, in my respectful submission, there's nothing in that authority which goes against the submissions I've been making.
Yeah.
So we do say that actionability of the duty to provide a VAT invoice is not only necessary, but in a sense inconsistent with the entire scheme of the legislation, which is properly seen as an administrative scheme. Whether VAT is payable or recoverable is a matter to be determined by and taken up by the trader with HMRC. The issue of a VAT invoice and other administrative rules and obligations comprises an important part of that determination, no doubt. But the suggestion that those obligations also result in a private cause of action, private claim in respect to those same VAT amounts, would cut across the operation of the VAT rules and HMRC's role in administering and monitoring the VAT system.
Does the, just going back for a moment, the additional statutory material which you handed up, does that go into bundle 2?
Well, yes, that would be the sensible place with the legislation at the back of bundle 2. It could be tab, I think we've reached 40.
You've got a hole punch.
Hasn't got hole punches
I
yet.
apologise for that.
Thanks. You've done yours. Oh, yeah.
Oh, thank you.
Yes.
And so, well, those are really my submissions on issue 1. We do say that when the court comes to look at it, it should stand back and consider all the indications in the round. It's not a matter of a single one being enough, but when one looks at all of the indications cumulatively, we say it paints a very clear picture against actionability. I haven't addressed directly the judge's commercial practice cross-check. It's in my skeleton, and I referred to it yesterday. We say he was reasoning impeccably in simply considering what was the practical position and how easy it was for someone actually to get a VAT invoice. It's part of the explanation as to why this is the first case, 46 years after the system began, when someone's actually tried to get a VAT invoice. It's not an issue which Parliament would have been expected to think was going to be a problem. My Lord, my Lady, can I then proceed to issue 2?
Yeah.
Which I hope I can deal with relatively briefly, as indeed my learned friend did. Issue 2 obviously doesn't arise in the event that the court agrees with Royal Mail on issue 1, that there is no statutory duty. This is the sole issue on which continuing duty is left, because contract and now EU law have fallen by the wayside in relation to continuing duty. My Lord, Mr. Justice Mann refused permission on issue 2, but permission was granted by Lord Justice Newey in the Court of Appeal. His reasons for doing so are set out at tab 21, paragraph 261. And I only mention this because he appears to have done so on the basis, as he put it, that the judge had departed from the contentions of counsel on both sides. Now, Lords, I will show that is strictly true on one point.
On the damage point.
Indeed, on the damage point. But that was by no means integral, let alone essential, to the reasoning of Mr. Justice Mann, and it was, indeed was hardly argued, wasn't argued below, because both parties had come with a different view. The two main points.
Can I just, if we just look at issue 2 for a moment, we've got it set out in the judgment, page 151. And the issue is framed: is any obligation in issue 1 above a continuing one, such that a new actual breach of statutory duty arose on each day on which the defendant failed to provide such an invoice? That's a question that I think we can answer one way or the other. If not, when did the cause of action accrue? Now, the way that Mr. Cordara framed the duty yesterday seems to me, at any rate, to differ from the way in which it's framed in the particulars of claim. I think, though we will no doubt get a written formulation, that the duty does not arise at all until the indeterminate point after the decision in TNT number 1. So that makes answering the second part of issue 2 quite difficult.
Lord, it's right to say that Mr.
Unless we just do it by reference to a formula and to say that...
Yes. Well, Lord, it's right to say that Mr. Cordara has handed me just before the court sat a formulation, and one possibility is that you could hear from Mr. Cordara on that now. Obviously, I haven't had much of a chance to consider
Well, I think it might be helpful before you respond to know exactly what the duty is.
Indeed, indeed.
Right.
Well, I'm grateful to my new friend of the court. This is the homework set yesterday. And the I won't give any more background than is on this sheet of paper, but the distinction which we propose
Just
is...
read it first.
I'm loath to add anything. My lady friend is speaking. I'm here to answer questions, of course.
Yeah. Stage 1, I think, is the pleaded duty, isn't it?
Yes. It is.
And stage 2, I think, was new yesterday morning.
No, but I can explain why it appears to be new. If I can just say in a sentence, I'll make this good later if need be. It's all in the skeleton on issue 2. And I thought yesterday this debate came up under issue 1. In a way, of course, it crosses both issues. But I was author of the skeleton on issue 2, which speaks about the if I could just give you the reference, skeleton number 2 at paragraphs 57.
Page?
Forgive me. Page 16 of the 45 of the bundle.
45.0.
It's still oblique at 57. It gets clear at 1662. But this is where this appears, I fully accept. So that the last sentence of 57, under the heading Analysis of Data Breach, unfortunately, was Justice Mann then proceeded without inquiring or setting out precisely what kind of putative duty has to be assumed, e.g. how broad, whether absolute or tempered by considerations of knowledge and reasonableness, and subject to what range of remedies. So it peeps out there, and then in 60, if I can just invite the court to glance over 60 to 62, and the difficulty for which I apologise is that's not clear, that's not labelled at all as lining up with reasonable excuse. So that's entirely my fault, which I apologise. But in substance, that's, as it were, the the background to
Yeah.
the document of his tax.
Right.
So you're saying the duty is that which is defined in General Regulation 13.1, and it must be carried out within 30 days of the supply. But if it's not performed, if it's not performed, the breach continues, but it is not actionable at a point when there is a reasonable excuse.
Precisely.
And therefore it is not actionable until there is no reasonable excuse.
Precisely. I'm obliged.
Lord, I obviously need to give some consideration to the formulation, but can I offer some initial observations? But it is an important matter, the formulation of a duty and its breach. We had, of course, seen paragraphs 57 and 60 to 62. We didn't appreciate that they were bound into, they were now being bound, I think I can say, because this wasn't the way it was put below, bound into breach or actionability of breach in this way. And we had addressed those arguments and dealt with them by pointing out that knowledge of the breach wasn't really relevant because, of course, a statute is always speaking in the interpretation of a European decision, just like a domestic decision takes you back to the time when the original enactment of the section, and that is declared to always have been the law. So we thought that was the answer. This is a different way of putting it. My Lord, my Lady, at first sight, we have difficulty with this analysis. What we have is breach of duty is aligned with the pleaded duty, which is, and this is precisely what we rely on for on issue 2, continuing breach. It's clearly not a continuing breach. It's a supply in the UK to a taxable person within 30 days. Invoice to be provided then. You don't do it, you're in breach. It's a one-off breach. That is effectively our main submission on issue 2. Now, therefore, breach must, on this analysis, come together with the duty at the 30-day stage. So at the 30-day stage, when Royal Mail doesn't produce the invoice, it has not complied with the obligation and it has breached the section. And what I understand Mr. Cordaro to be reserving to stage 2 is that on the assumption, which we don't dispute, that a breach is not actionable until damage is suffered, he must presumably be saying that no damage is suffered until the person in the position of Royal Mail doesn't have a reasonable excuse anymore. The reasonable excuse has disappeared years later, potentially.
Yeah.
Now, Lord, we have great difficulty with that because it's not clear why damage will coincide with the lack of absence of reasonable excuse.
He doesn't formulate the, as it were, suspension provision, suspension of, or not even suspension, the delay, deferral of actionability by reference to damage.
He doesn't. But what else can it be that makes it not actionable until then? There is a duty and there is breach back at the 30-day period.
Yes.
So what postpones it to be actionable until later? If it's not damage, that's the other ingredient of the tort.
Yeah.
I can't see any other ingredient of the tort. So it doesn't say that, but I'm inferring by logic. Well, I hope by logical inference, unless I'm told I'm wrong, that the only way I can see that a submission can be made, that actionability doesn't arise till years later, is in some way that is when damage suffered, and therefore that completes the cause of action.
Otherwise, one would have to import knowledge into the duty.
Indeed,
Knowingly.
which he has now abjured in his formulation of the duty at stage one. He has now said, I hadn't understood this quite yesterday, which way he was going, if I can put it that way, but he's now said, no, there's no knowledge in the duty. The duty is simply an absolute duty to provide within 30 days, which we would respectfully agree. So that logically, that's duty, that's breach, and therefore, in some way, actionability must be being lined up with damage. But that just doesn't work, because damage won't necessarily follow whether or not there was a reasonable excuse. There could be cases of damage where there's no reasonable excuse, or no damage. The other, conversely around, and that I can perhaps develop some examples in due course when I've had a little chance to think about it. But it doesn't seem to me that it is necessarily the case that actionability, the damage, that there's any argument that damage can be made in that stage. Of course,
so what we get from Section 69, of course, is that the person has failed to comply necessarily with the relevant regulatory requirement, i.e. to provide a VAT invoice. But that does not give rise to a liability to a penalty if the person in question can satisfy the Commission's or tribunal that there's a reasonable excuse.
Precisely, it's only the penalty that's being...
And the failure is to be disregarded for the purposes of subsection 3. Yeah.
So there's still the failure's still there. The failure's there at the early stage.
Yeah.
It's simply relieving of a penalty. And bizarrely, it's relieving of a penalty which Mr. Cordara's case is just irrelevant to this statutory duty, because it's not an adequate, it's a minor penalty which on his first submissions on the first part of the case can always be forgotten about, because it is so minor and isn't an incentive to anyone and really has nothing to do with the need for an actionable duty. But here it is suddenly stapled back into the duty by way of actionability. Now, of course, our first submission, rather than this doesn't work, our fundamental submission is that what is clear is that at stage one has the duty and its potential breach. And
if we move away from the particular facts here, go back to your example. No invoice issued because there was a fire at the offices of the supplier. But the trader who ought to have got the invoice may well suffer loss in that accounting period that straddles the 30 days.
indeed,
Because he can't deduct his input tax.
Indeed. And there's no objection to say, well, there's a reason we couldn't provide the invoice. On the face of it, there's a duty, there's breach, and there's loss. So on his formulation, cause of action is accrued at that stage.
On day 31.
On day 31.
Despite the supplier possibly having a reasonably arguable case for saying I had a reasonable excuse.
Indeed. What these really illustrate, going back to issue 1, is that this is an attempt to put two different parts of the regulatory system together and turn it into an actionable cause of action, which simply doesn't work. One immediately sees the difficulties of trying to staple together two completely separate administrative parts of the system. There's no actionable duty here at all. But if there is one, if I'm wrong on issue 1, as we're assuming at this stage, then quite plainly on Mr. Cordara's own formulation of stage 1 now, not only duty and breach arise at the 31-day point, but also damage potentially. Can't be any part of the case on actionability that it only arises later on. And I'll come back to my suspicion, which I hope I can make relatively briefly, in relation to the target that I thought I was facing. So the same point applies there. So point I was just going to make very briefly, it is a minor point, that the basis on which Lord Justice Newey gave permission to appeal was because of this rather, we would say, rather minor point as to whether or not you need damage as part of the cause of action for the breach of statutory duty. But that was not integral to his findings, the findings that we had argued he should make on sub-issues 2 and 3, which we say are impeccable. So the first conclusion, we summarise the findings of Mr. Justice Mann on this on issue 2, paragraph 4 of our skeleton argument on issue 2, and that is the tab 7 skeleton that I was wrongly taking you to a few moments ago. But the first...
Sorry, which paragraph?
Paragraph 4, my lord, on page 67A, starting on 67A. Yeah. So the first sub-issue is his finding that his determination that a cause of action for breach of the statutory duty to provide a VAT invoice accrues at the point of breach, not the point of damage. That's judgment at paragraph 216, with, as you see, the preceding analysis set out. And this is the point that was not argued by the parties, who both assumed that damage was required, and so accrual was on damage. The second sub-issue, which he expressly considered on the basis he was wrong on damage being not required, his second determination was that damage occurred when the customer could have made a reclaim of input VAT had it been given an invoice. Judgment paragraph 222. We say the judge was absolutely right in his analysis on this, and it itself it's a knockout blow.
So that's when the trader puts in his next VAT return.
Precisely. Effectively. And thirdly, sub-issue C is breach not continuing. So 2 is really accrual, and then 3 is breach was not continuing. There was a breach on the day when the invoice ought to have been provided, not a further day, breach on the day after that, or the day after that, or the day after that. And this analysis, judgment 226, and then the analysis is set out in my skeleton.
Yeah,
and again,
one thing to say that the supplier is still in breach.
Yeah.
It's another thing to say he is again in breach.
Precisely. And the cases emphasise that difference. The fact that breach remains unremedied doesn't mean there's a further breach. It's only in exceptional cases you've got continuing duties. And this is not one. Well, can I just say a few remarks on the first sub-issue A about whether the claim for breach of statutory duty accrues on damages or breach. It was, as I say, very much a subsidiary point at trial, on which there wasn't full argument, because we had assumed, as had the claimants, that the cause of action accrues on damage because the claim was one in tort. And the judge explains his reasons for taking a different view at paragraphs 213 to 214 of the judgment. Our case, I'm not going to go to it now, can be seen from footnote 2 of our skeleton on page 67B, which I'm afraid goes over onto the next page. It sets out an extract from our skeleton below as to why we had assumed that it, or reasoned that a cause of action didn't accrue until damage. Just for your lordship's note, there's a further passage in Clark and Lindsell which isn't cited in that passage in the skeleton. In case your lordships would like to see it, I'm just going to give you the reference unless you'd like me to take you to it. It's paragraph 960, and in the bundles it's in bundle 2, tab 44, page 320. And I'll just quote the crucial sentence. It says, in most cases, a statute will not give rise to a cause of action unless its breach has caused damage to the claimant, though occasionally a statute has been construed to make a breach actionable per se. And then there are various references, including to the case of Ashby, which I think Leonard Friend referred to yesterday. And we had some difficulty, and still have some difficulty, in seeing what would render this breach actionable per se. There's no particular indication given by the judge, and there was some rather unsatisfactory on the hoof debate on this issue, and we went away and had a look at it, encouraged by the judge, and came back and said we couldn't see any reason. But
well, it's all in 216, isn't it? His reason. It's all about the injunction.
Lord, yes.
He says that you on day 31 you can get an injunction, even though your prescribed accounting period hasn't yet expired. That seems to be the point.
That may be right, and that could be
and you said, well, that's a quiet time injunction because there's a threat of loss. The date for my VAT return is coming up. If I haven't got the invoice, I can't deduct the input tax. Therefore, you can see that loss is about to happen. Therefore, grant the injunction.
Well, yes.
Yeah. So, I mean, what?
Yes. Well, Lord,
And it's different from some quiet time injunctions, which are occasionally granted in anticipation of a breach, for fear of
indeed, it doesn't even go that far. It's in anticipation of loss.
there is a breach.
We say. He said no, there's no breach because the damage hasn't been.
Yeah, but on this premise, there is a breach of the duty. So Mr. Cordara says, but the customer hasn't yet suffered loss because the moment for accounting to the customs hasn't yet come.
Yes, indeed. Lord, the difference between the two, the difference created by my law, Mr. Justice Mann's holding was relatively minor in the context of the case. It postponed because the two dates are very closely linked.
Isn't it? 3 months maximum.
And probably less, indeed,
Yeah.
indeed, precisely, because it would simply move time from the date when the VAT invoice should have been supplied to the date immediately following the VAT return, the next VAT return of the claimant. It would depend on the particular cycle which the particular claimant was on. Could be a month, could be 3 months, could be up to 3 months. So it was a pretty minor difference, although it does occur to me it would be a very major difference from a learned friend's formulation, because if actionability is related to damage, as I'm speculating, it would blow all that out of the water. But Lord, as far as we are concerned, it is a relatively minor matter, and although obviously his holding gave us a minor advantage, because it, as it were, moved the limitation by a month or 3 months in our favour, it's not something on which I propose to make further submissions. Yeah. On the date of accrual, but none of the judge's reasoning in any way infected his reasoning or his holdings on the two important issues on accrual and continuing duty. He considered them on the basis that he was wrong on that first point, and nothing, my learned friend hadn't pointed to anything that, as it were, lingers through or faults his analysis on that basis. Well, we say that the judge was right to hold that the date of damage is, as we'd submitted, at the date of the next VAT return, generally required quarterly, when the customer could have made a claim for input tax, but didn't in fact do so for want of a VAT invoice. Lord, the judge reached that view because it is at that point of time that the customer is worse off in the amount of the unclaimable VAT. That's paragraph 221 of the judgment. I.e., at the point when the customer could have included it in his return and didn't. And Lord, we say the judge rightly found that was the only conclusion open to him on the basis of the claimant's pleaded case and the assumptions on the basis on which the trial was conducted. Again, paragraphs 220 to 221. Notes that as the pleadings, it is noted in the judgment, that damages claimed in the common form particulars of claim is, in particular, the inability to claim credit for or to recover input tax. Reference for I'm not going to go to it again because it's adequately quoted there. For the Harrier claim, it's in the particulars of claim, it's tab 23, page 280. The domestic statutory duty claim is at paragraph 35, and the claim of damage is at paragraph 40. But we say that analysis is clearly correct in the light of the authorities. I've already made my submission in anticipation on the particular point that Mr. Cordara developed yesterday about the pristine nature of the claim or the interest issue. It's quite right that the claim itself could have been made later in a subsequent return. Clearly, under the regulations, one's entitled to make a claim a later period. If one's a duty to make it in the first available period, but if you haven't got the VAT invoice, it can clearly be made later. That doesn't mean there isn't loss at the first opportunity you have to make the claim and get your money. As at that date, you're being kept out of your money by our failure to make to provide the invoice. And if it's no answer to that to say, well, HMRC might have wrongly refused the claim at that point, because if HMRC had wrongly claim, then the claimant could have vindicated its position in law, and ultimately, if it had got a judgment saying that the sum was indeed as claimed in the invoice due and owing, you'd get interest compensation.
I've had that point raised in a different VAT case. I forget which one it is now. It might have been one of the Leeds City Council, I think. It was said, oh, well, HMRC took a wrong view of the law, but the answer is, well, go to the tax tribunal. Indeed. If necessary, go to the Court of Justice.
Indeed. That's the answer. And there is, and the point is that at the end of that process of going to the tax tribunal or going to the Court of Justice, there will be an order that puts the claimant back in the position he should have been in if he's successful. And that is what we independently have that's why we independently, of course, damaged the claimant, because we've stopped the claimant being able to get himself into that position. Because, of course, if he can't even make a claim because he hasn't got a VAT invoice, then he's not going to later recover the interest from the revenue. If he only makes a claim 10 years later, the revenue is not going to say, oh, well, I know you made a claim now, you could have made a claim 10 years earlier, and therefore we'll give you those 10 years interest. Obviously, the revenue is not going to do that. So we, on the hypothesis of our duty and our breach, have inescapably caused measurable damage at the date of our first failure, we say our only failure, to provide a VAT invoice.
Actually, not at that date. Not at that date. A couple of months later.
A couple of months later.
Yeah.
And I don't believe I will need to go to it wasn't seriously disputed. Law Society in Sefton, in our skeleton, cause of action accrues where breach leads to relevant and measurable damage. And being kept out of your money is obviously relevant and measurable damage. That's in the House of Lords, paragraph 56, Authorities Bundle 4, tab 15, page 639. And the fact that the loss can't be quantified, which in any event isn't the case here, or that more damage may occur later, is simply not to the point. As long as some measurable damage has been suffered, then the cause of action accrues. And that is Spencer, paragraphs 24 and paragraph 31. I quote the passage in our skeleton argument at paragraph 19, so I won't take your lordship to the passage itself. It hasn't been disputed. Paragraph 19, one of our skeleton argument. Now, in some of the cases, it is of course right that one breach may lead to different damage and new causes of action on separate occasions. One can perhaps illustrate that with two different cases with different patterns. The first is the Phonographic Performance Limited case, the PPL case, decided by the Vice Chancellor, and that is in tab 16 of Bundle 4. Maybe I don't need to take this.
But I mean, the point there was that every time a song was played without paying PPL, PPL suffered a different loss.
Indeed. There was a continuing breach of the directive in the background. When I come on to continuing breach, I'll say that's clearly not this case. But there was a continuing breach in the background of failure to implement. And every time someone played a song which the person couldn't get compensation because the directive hadn't been properly implemented, there was fresh damage. Each of those was a different occasion. And so the claimant could recover the last 6 years' worth of uncollected payments, notwithstanding that the breach of the directive had been at an earlier stage, had been an earlier time and would have been more than 6 years ago. That's the point of that case. So the two stages are, one, the duties continuing, which I'm not dealing with at this stage, I'm talking about accrual. The point is there's a fresh cause of action on each occasion when PPL suffers consequential damage. The basis for the court's decision is paragraph 25. It didn't consider that all subsequent damage can be attributed to the initial breach. Rather, PPL was deprived of a right on each occasion, subsequent occasion, when a sound recording was played in circumstances which, because of the breach by the UK in failing to implement the law, because of the breach, did not constitute a copyright infringement. So that's the holding. I have to revert to PPL on continuing duty, but those are the principles on accrual. Now, that case can be contrasted with Spencer, which is the other European case on failure to implement a directive, which is tab 12 of Bundle 4. another case where there was an action. This is the drivers. This is the case where the UK had failed to implement a directive, with the result that there was no adequate scheme for compensation for certain accidents. Well, it might be helpful to take the Spencer, which is, as I say, bundle 4, tab 12, decision of the Court of Appeal, Spencer and Moore. Justices Waller, Carnwath and Stanley Burnton. And in that case, the UK had failed to implement a directive, with, as I say, the result that there was no compensation for certain accidents. And the claimant, who had suffered personal injuries, argued that a cause of action accrued on each day that the UK remained in breach for failure to implement the directive. And hence it didn't matter that their own claims were brought more than 6 years after the date of their relevant accidents. So they were, on the face of it, they were out of time because the car crash of Mr. Moore and the injury of Spencer had occurred more than 6 years before the claim was brought. But they said, aha, the directive is there's a continuing breach of the directive, and therefore we're in time. Now that claim failed because, unlike in PPL, the claimants did not suffer a series of separate accidents, but rather their claim arose out of one accident, and it was on that day that they suffered measurable damage by reason of the failure to implement the directive. And one can see from paragraphs 34 and 35 is the best illustration of this. As one can see in that case, this is phonographic, commenting on phonographic, each breach did lead to different damage. In Mr. Moore's case, it's quite different because he's not suffering a series of accidents, each of which would produce a fresh cause of action. His claim arose out of one accident, and was at the date of the accident he suffered damages explained above. In the next paragraph, the fact that the UK could have remedied the situation is not to the point. The position seems to be clear. The UK was in breach if it failed to implement the directive. I would accept that so far as Mr. Moore was concerned, the UK must be assumed to have been in continuous breach up until the moment he was injured by an untraced driver. Once Mr. Moore suffered damage from that breach, that completes his cause of action against the government. The obligation of the government to pay Mr. Moore, once he had suffered damages for their failure, was to pay damages. So once he'd suffered damage, completes the cause of action, and no subsequent cause of action, importantly. Now we say, applying those principles to the present claim for breach of statutory duty, we say the position is clear. One comes back to Regulation 13.5 of the 1995 regulations. That prescribes the time by which the VAT invoice shall be supplied. 30 days from the time when the supply is to be treated as taking place under Section 6 of the Act. And that duty applies, obviously, in the case of each supply, each separate supply. The duty to supply an invoice within 30 days arises. So in respect of each supply made during the claim period, Royal Mail was under a duty to provide a VAT invoice by the end of the prescribed period, running from the time of supply. And the time of supply, of course, is when the postal services were performed. That was Section 6.3 of the Act, which I think was you were taken to, I think. So the statutory obligations required the provision of an invoice by Royal Mail within a prescribed time after the supply, in respect of the supply, in respect of each supply. And on the expiry of that period, in respect of each supply, there was a breach of the obligation to provide a VAT invoice, sounding in damages shortly thereafter. And that's when measurable damage on the second principle was suffered. It will have been on the date of the claimant's VAT return in which it could first have claimed the deduction of input tax in respect of the service. The material damage was suffered on the date of the claimant's return, and there's no different or fresh damage suffered later, bringing the case into the PPL category, when new recordings were played. It was a new act. It's simply that, as Lord Sir Timothy Lloyd put it a moment ago, it is simply that damage continues unremedied while Royal Mail doesn't provide an invoice, even out of time. So one-off
breach continues unremedied.
Breach continues unremedied.
Damage has been suffered.
Damage has been suffered, and damage, yeah, indeed. There's no fresh damage upon every opportunity to file a return, there is simply, if anything, or there's an accumulation of the interest claim as time goes by, there's a further opportunity for Royal Mail to remedy its breach, no doubt, by supplying late VAT invoice if it chooses to. And that would potentially stop damage being suffered. The measurable breach would come to an end. And one can test that. If one was pleading the damage in this case, one wouldn't plead multiple breaches each 3 months over the years and years and years. You would say you should have provided the invoice by X date. You didn't do so for 3 years or whatever. There's breach, there's damage. He now tries to perhaps avoid the effect of that by reformulating the reasonable excuse provision, folding it into actionability. But the reasons I've already developed initially, and if I may, I'll perhaps think whether I need to say anything more on that, if I may. That doesn't work either. That doesn't provide any sustainable breach and duty. Lords and Lady, that leaves then continuing duty, the judge's third finding. If the duty is a continuing one, this of course has the consequence that the claimant is in principle entitled to recover damages in respect of breaches committed by the defendant in the 6 years preceding the claim. It doesn't wipe out limitation completely. It simply means that the duty continues and therefore potentially the breach can occur at a later stage. What it does is it doesn't enable the claimant to escape from limitation completely, as it were, but it may extend the window that they'll be able to claim in, because instead of being completely out of time, they may have 6 years to claim, because breach will be continuing at the later stage. Now, in relation to whether the breach was a continuing one, the judge concluded that it was not, and there was no breach day by day. He considered that the position was plain at paragraph 224. And the essence of his reasoning, which we respectfully adopt, is set out at paragraph 226 of the judgment. Well, I'm not sure I can improve on this. He says, question of whether the breach is once or for all or for continuing is a question of construction of the obligation and the nature of the act in question. In my view, it's plain that if the failure to provide an invoice was a breach of a statutory obligation, it was a breach on the day when it ought to have been provided, not a further breach on the day after that and thereafter day by day. Obligation under Regulation 13 is clear. It provides for the provision of an invoice where taxable supply is made. Paragraph 5 provides when it's to be done, 30 days. When it's not done in time, there's a breach, and the nature of the breach is a failure to supply the invoice within 30 days. That remains the breach on the first day after the 30 days, the second day, and thereafter. No separate breach on the second and subsequent days. Breach is always the same as it always was. When asked the question on, say, day 5 after 30 days, did the supplier commit a breach today? The answer would be no. Committed a breach by the end of the 30 days from supply. In my view, the conclusion contended for by Mr. Goddard cannot be maintained in light of that. We say that is absolutely right. All I will say in addition, Lord, is that there are clear authorities that continuing duty is the exception, not the norm. If someone is trying to point to a continuing duty, one has to effectively find something exceptional in the statute pointing to that effect. And one sees that in some of the directive cases, like PPL and Stefan, where what one has is a continuing failure by the UK to implement an obligation which one can immediately see arises day by day. But that's obviously not the situation here. We're talking about Royal Mail, commercial trader for these purposes, not complying with an obligation which is time specified by 30 days. Absolutely no indication of a continuing breach whatsoever. And we cite authorities for why continuing duty is the exception, not the norm, in our skeleton. Just for the court's note, is paragraph 26(1). Continuing duty is the exception, not the norm. We cite and there set out extracts from Vi Industries, Peter Brown and Equitas. And then we make the point that whether an obligation has the character of a continuing obligation depends, as my Lord, as Mr. Justice Mann said, depends on the construction of the obligation and the nature of the obligation in question. There is a very helpful consideration of a case which did give rise to a continuing obligation, in a case that wasn't a European directive, in the Equitas and Walsham Brothers case. It might be helpful, I don't know whether it would assist the court, for me shortly to take you through that authority. It's an illustration of the sort of reasoning process one goes through. That is bundle 4, tab 14 of the bundle. No. Yes. Yes. So this is a case arising out of the turmoil in Lloyd's in the 1980s, 1990s. The question there was whether duties owed by Walsham as reinsurance broker were continuing duties to the claimants or not. And one can see the analysis commences at paragraph 59 of the case, on page 583 of the bundle, page 152 of the report. And one can see that there's the issue set out. I can see the next, whether the duty owed by Walsham was a continuing duty, i.e. as Equitas contends, the duty to remit funds which was breached on the first day when those funds ought to have been remitted, and breached afresh every day thereafter when no remittance was made, or a single duty. For these purposes, there's no need to distinguish between duties in contractual and restitution. And then paragraph 60 is quite important because it recites the nature of the continuing relationship, which we say is very different to here, between the parties. Features of the parties' relationship. A continuing relationship extending potentially over many years. Second, broker's duty is not limited to collection and remittance of specific amounts, involves administration of the syndicate's reinsurance policies generally. Third, heavy reliance on by the syndicates on the broker's ongoing performance. Fourth, broker is an accounting party and under a continuing obligation to maintain accounts and other records, produce them as required. Fifth, continuing nature of the broker's responsibilities is implicit in the code of practice, in particular the duty recognised by paragraph 7.2 to operate insurance broking accounts. We say by contrast, what we're looking at here is two commercial traders and the provision of a VAT invoice, maybe a one-off, maybe no other trades between them at all. In this case, of course, there was a continuing relationship as supplier and postal services, but that's purely a continuing contractual relationship, completely different from Equitas. And then one sees, I won't go through the full detail of the consideration of the previous authorities. From paragraph 61, Mr. Justice Melson considers a number of authorities, mostly holding against a continuing duty, such as, for example, Barimani and Gates in paragraph 61, tenant's obligation to use insurance proceeds after a fire was not a continuing obligation. A quote of Lord Griffiths at the end, which is helpful, we say, to us. If an obligation is to perform an act by a given time, once that time has elapsed and the act has not been performed, there is a breach of a single obligation, not a continuing one. Of course, we've got a 30-day obligation, time obligation here. The fact that it still lies within the power of the lessee to perform the act cannot affect the nature of the obligation. And then I'll pass over 63. Paragraph, which is another consideration of another case. Paragraph 64, the relationship of landlord and tenant, like that of a Lloyd's broker and the syndicate for which it acts, is an ongoing relationship. Clearly, this is not enough by itself, and it was not enough in these cases to turn the tenant's obligations at issue into continuing obligations. So it may be necessary but not sufficient that you've got a continuing relationship, perhaps. Don't find it surprising that the attempt to characterise the tenant's obligations as continuing obligations failed, essential artificial device to get around the waiver, etc. But it remains for consideration in every case whether the relationship of the parties and the particular obligation in question is such as to give rise to a continuing obligation. And then we have Bell and Peter Ball, and that's one of the other cases we've cited, and perhaps looking at it here saves one from having to go to it. Walsham also relied on the decision of the Court of Appeal in Bell and Peter Brown, as I said before, Peter Brown. solicitor's negligence case where the defendant's solicitors failed to comply with the claimant's instruction to ensure that his interest in the matrimonial home was properly protected on the house being transferred into his wife's name. It was held that the limitation period in both contract and tort began to run when the transfer was executed, and that thus the claimant's claim for time barred, notwithstanding the breach, would have been remediable by the solicitors at any time before the wife sold the house, which had occurred less than 6 years before the commencement of the action. However, the breach had occurred when the claimant failed to lodge a caution to protect the claimant's interest at the time of the original transfer. Failure thereafter to make good the omission didn't constitute a further breach. The omission was simply that the existing breach remained unremediable. And then the important passage from Lord Justice Nichols, which I think we cited in our skeleton argument, contrasted this normal case where a contract provides for something to be done and the defaulting party fails to fulfil its contractual obligation in that regard at the time when performance is due, with the exceptional cases where on the to construction of the contract, the defaulting party's obligation is a continuing contractual obligation. Now there, of course, they're looking at contract, which is a contract case, but the same will apply in allegation of breach of statutory duty, and so on. And I have to say, Peter Brown was an exceptionally strong case because the justice of the case was monstrous. This was before the Latent Damage Act, and he may have one of the impulsions for it. So the poor husband had no idea, no way of knowing that the caution hadn't been lodged, and yet was out of time by the time it was discovered, and by the time it came. And yet, the court held in a very straight, tough decision that the claim was never out of time barred. 67, Walsham emphasises Lord Justice Nichols' use of the word exceptional when referring to continuing obligations. I do not understand this to be imposing an independent requirement that there should be something exceptional about such a case. In my view, Lord Justice Nichols was merely recognising that in general obligations fall to be performed once and for all on the date of performance, and the failure to perform them does not give rise to a series of repeated breaches. Nevertheless, the concept of continuing obligations is well recognised, and in some very ordinary cases, such as landlord obligations to keep premises in repair, it is standard. And I accept that. That is what's meant by exceptional. It's not you need something exceptional on a particular fact, but it is most duties don't fall into this category. And then paragraph 68 is perhaps the last paragraph I would show the court.
Well, I mean, in the landlord and tenant context, it's certainly been held by this court that if you've got an obligation to build something by a particular date,
repairing, yes.
it's a once for all breach, and you can't infer a continuing breach from the presence of a repairing covenant.
So, and that's a case of a continuing relationship where doesn't translate into a continuing breach.
Whereas the repairing covenant is expressly continuing.
Yeah.
Yes, precisely.
And necessary.
Yes.
So that's why one
usually says throughout the term.
Yeah.
Indeed. And that's why one has to start with the obligation.
Keeping.
Yeah.
So one starts with the obligation itself. One analyses the obligation in its proper context. And we say here, nothing more than any normal standard obligation on the assumption there is an obligation to provide an invoice by a certain day. And this is the by a certain day, which is particularly important and antithetical, we say, the submissions of the firm makes.
Yeah.
And thirdly, and this point I think is already perhaps taken by the court, the fact that the breach is remediable doesn't affect the nature of the obligation. And that again is Peter Brown, page 500 F2H, quoted in the judgment of paragraph 227. It's of course the case you can remedy it month by month in our case, quarter by quarter by quarter. It doesn't affect whether it's continuing.
So, in fact, the judge was right for the reasons he gave in those paragraphs.
Yes.
2, 3, 4. That's your submission.
It is. And just dealing with finally, deal very shortly with one or two submissions which the claimants make in their skeleton. But they say each lost opportunity, i.e. each VAT quarter, which occurs when there's no claim, is analytically separate from any previous one. It applies a specific individual period with respect to the VAT return to it. On each such occasion, a fresh actionable accrual results. We say that's simply wrong on the authority of Peter Brown and other such cases. They appear to be saying since the notional door for making a claim for that deduction isn't closed, and the deduction can be made even after the quarter in which the claim the deduct could first have been made, therefore the obligation is continuing, or no damage is suffered until then. But the nub of the argument is we say not sustainable in the light of the decision of the Court of Appeal in Peter Brown. And then we have, I was going to address the submission that was made about no breach until knowledge has been suffered. On the original formulation of the argument, the answer to that is Commission in Sweden, which is cited in our skeleton argument. This is the case that I referred to yesterday. Yes, Commission in Sweden is in paragraph 35 of our skeleton argument. As the court there said, and it's familiar to an English lawyer, where an obligation derives from an interpretation of EU law by the courts clarified and defined the meaning and scope of the rule as it ought to have been understood and applied from the time of its entry into force, so that member states should from that time have interpreted and applied EU law as it follows from the court's judgment, even if that was later. Commission in Sweden, paragraph 35. So on the original formulation, well, we didn't know, no one knew about this till much later. So that's absolutely nothing to the point in terms of determining breach and damage. And on the new formulation, you have my suspicions. Well, lady, subject to anything yours, those are my suspicions.
Thank you. Thank you very much. Yes,
Quite-
Mr. Fiddle.
My lady, my lords, you have my, obviously my initial submissions well in mind, so I can be brief.
Yes.
Can I start with zip fit and simply, in response to my lady friend suggesting that room was somehow left for discretion, just assert the contrary, which is that given the paragraphs I'm about to refer you to, it's clear that either de jure or de facto, the alternative evidence route is not open to someone who cannot show that the tax was actually paid. So that's my assertion.
Was actually paid
By the supplier.
Or by the customer.
Yes. But by the
Paid over to fiscal authority by the supplier.
my language was very loose. So let me regroup. The alternative evidence route is not open either as a matter of law or as a matter of fact to a customer who does not have obviously doesn't have the tax invoice and who cannot show that the maker of the supply to it has accounted properly to HMRC for the associated output tax. And it's the practical position, however it is reached, that we submit matters, and we point to two things. First, the view taken by the Supreme Court at para 24 of the judgment on the reference, and secondly, the comments made by Lord Justice Henderson at 116 to 119. So those are the things I'm just going to refer to in reply. Could we just briefly go to the Supreme Court, which is Vol 5?
5.
Yeah. Yes, Vol 5 tab 3. Vol 5 tab 3. And
No.
2.
no,
Tab 2.
2.
sorry, I apologise, thank
Yes.
you, so sorry. And hopefully it is para 24. Around 24, my lord, between E and F. So, para 24, page 1024 of the report. At E, the their lordships say this. However, the Court of Appeal reached the same conclusion as the tribunals below on the invoice issue, paras 91 to 119. After reviewing the case law of the Court of Justice, the Court of Appeal held that it was a necessary precondition for ZipFit to be able to exercise any right of deduction of input tax in respect of the services, that it should be able to produce VAT invoices which showed that VAT had been charged in respect of the services in compliance with, and then I leave out the references. The Court of Appeal agreed with the tribunals below on the question of the exercise of discretion by HMRC. If HMRC treated ZipFit as having paid input VAT in respect of the services, ZipFit would receive an unmerited windfall, etc. So
in this case, of course, we know that Royal Mail did not account to HMRC, but the proposition to be able to produce VAT invoices which showed that VAT had been charged in respect to the suppliers of the services is not the same as saying that the supplier had paid the corresponding tax to the fiscal authority.
My Lord, I accept that, and that's why the second step, it doesn't get me all the way home, I fully accept that. The second step is, with that in mind, to look at Lord Justice Henderson at 116 and 119, and this is really just an extension of the exchanges that the court had with my own friend earlier today. So that's volume 3, tab 2. And report page 5765, and the court's already looked today with my learned friend at the earlier paragraphs, but if we look at this final page, 116 starts just at the bottom of the previous page, there are three passages, 3 sentences on this page, all to the same effect. The first is between A and B, and the point is made in line 5. Since ZipFit is unable to produce such an invoice, I am unable to see any grounds upon which HMRC could properly conclude that ZipFit should nevertheless be allowed the deductions claimed to the detriment of the general body of taxpayers. At E, which is clearer, the real issue, as I see it, is whether ZipFit can claim a deduction for VAT by treating the original price as VAT inclusive without producing evidence that the tax in question has been duly paid by the supplier. His Lordship goes on to say his conclusion renders that unnecessary, renders the question of the status of Article 2269 and 10 unnecessary, and that we say is the key to seeing ZipFit as effectively, or as in fact, closing the door to alternative evidence where you cannot produce evidence that the tax in question has been duly paid by the supplier. And there's nothing.
The particular problem in this case arises from the fact that to any ordinary mortal, the UK legislation said these supplies were exempt. Let us suppose that we're dealing with an ordinary standard rated supply. The supplier produces no invoice. The customer has no idea whether the supplier has or hasn't paid VAT. The earlier passages from Lord Justice Henderson's judgment suggest that that doesn't matter. So is the duty for which you contend limited to cases in which the customer cannot show that, or where it matters that the customer cannot show that the supplier has paid the VAT. My understanding was that the duty for which you contend applies across the board to all taxable persons who make supplies, whatever the circumstances in which they make them.
Correct. So,
Right. So does that mean that you interpret ZipFit to say that the customer can never deduct input tax without an invoice?
no, the duty is, as my lord put it to me, so it's always there.
Yeah.
Secondly, the Royal Mail say on the question of whether it's actionable, but there is a second channel and you can go down it. And that's obviously a very important counter-argument. And we respond by saying, but in a case such as this, and I'll come back to that phrase, but in a case such as this, where for whatever reasons, good or bad, the supplier is saying, I'm sorry, I'm not going to be giving you a VAT invoice. I don't agree with your characterization of the transaction. It will be the case that that supplier will not have paid the output tax. It's just night and day, two sides of the same coin. So the right question to ask in a case such as this, which is without any nuances, willful refusal to hand over a VAT invoice, is, well, what is there an optional channel? Answer, by definition, sees it fit. There won't be. And at that point, your lordships then engage with, well, in this case, in that situation, should we or shouldn't we construe the parliamentary intent in the context of the overall operation?
Well, yes, well, that's all very well, but I'm just going back to the formulation of the duty that we got this morning.
Yes.
It's not limited to a case in which there is no other means of exercising the right of deducting input tax, which, as we know, is a fundamental feature of the VAT system. It's expressed to be unqualified, and in the situation that you have just outlined, the supplier doesn't have a reasonable excuse for not supplying the invoice. He just willfully refuses to. But nonetheless, in many cases, the customer will be able to exercise his right to deduct the input tax, won't he?
The key in my submission, I'm sticking to my guns that the duty on the piece of paper is absolute. But we get into this sub-debate very properly because it is said it doesn't have to be, it may be absolute, but it doesn't have to be absolutely actionable at all times. And indeed, on the basis that there's this other channel, it should never be actionable at all. That's what the Royal Mail position is, that it's an indicator against my case that there is this potential channel. To which I respond, well, in such a case as the present one, there isn't, and logically there won't be, by reason of the nature of this debate.
So the intention that we ascribe to Parliament is that the obligation to provide an invoice is actionable unless either the supplier has a reasonable excuse for not providing an invoice, or there is an alternative means of exercising the right of deduction.
No, I shake my head respectfully at that second option. Absolutely, in terms of the first sub-option, which we've dealt with.
Yes.
As far as whether or not one can use the second route, the alternative channel, that should not be seen, or the existence of the alternative channel should not be seen, as Royal Mail invite me to see it, as fatal to actionability at all. Rather, that then takes us into the actuality of any particular story. And in those cases, so Parliament, I submit, simply said to itself, we've got this duty where it is being broken and there's no reasonable excuse, it's actionable. Full stop in my analysis. Right. Royal Mail say, well, just a minute, surely Parliament would have factored in, as negativing all of that intention, the existence of the second channel, to which we respond, well, it may be that as an act of mitigation, the holder of this actionable duty, can go round the back door in some proper way and prove whatever they need to prove. But that should be seen not as going to undermining the existence of the actionable, A, of the duty, and B, of its actionability, but simply a circumstance in which, through self-help, the victim of the broken duty can rid itself of the damage.
Or I suppose you might say it goes to causation of loss.
Precisely. But given, I suppose, Parliament is to be taken to have anticipated the outcome thus far of the Zipfit litigation in the usual way, Parliament is to be taken to have known that there may well be quite a substantive class of cases where the alternative channel simply won't be operable. And this is one of them. So it's a circumstance. It goes to causation. It might be an act of mitigation. And if it's done successfully, then the actionable breach will never need to be the subject of litigation because you've just mitigated your loss. But it is not so root and branch an alternative that Parliament could be taken to have thought, well, we can leave it to the second channel, sees it fit in the current story. So it's best relegated to the causation stroke mitigation part of the analysis.
Yeah. Well, maybe it's not even causation. Maybe it turns out that you haven't actually suffered any loss.
My lord, precisely. We mitigate the loss away. So that, the only other thing, I'm not sure if this is helpful or relevant, but there was some, I think, debate this morning about, in the context of oh yes, that's right. No, this is relevant. There was some, there had been discussion this morning about the importance of the invoice in terms of recovering input tax, which is obvious, of course, to all. My Lord Sir Timothy Lloyd put an insolvency question to my learned friend scenario. And what that does is remind us that this entire debate is about where risk lies. So if that invoice is issued, then the risk of non-payment of the underlying output tax stays with the state. And that's the magic, as it were, of holding the VAT invoice. Where a VAT invoice is not issued and we go down the alternative route, then essentially risk of non-payment redounds to the disadvantage of the customer. It's a background point, but it's the way it
depends,
works.
doesn't it? Because it will depend on how whether and if so how the alternative channel is used.
My lord, yes, and it can
may work for the customer or it may not.
Indeed. But it would appear it will only work for them if they can show that the output tax has been accounted for.
Well, I wonder if that's actually right in that sort of situation. Anyway.
Well, it may be that...
This is not that case,
no.
And we don't need to speculate.
Indeed. The discussion this morning then went... there was some discussion of possible tension. I think my Lord Justice Lewison made the point within ZipFit, centering on 113, and then my learned friend took you to the Société Générale case. I'd just like to dip back into that and make a short point there, and then elaborate very slightly on the Riesdorf case, which is referred to in it. So, Soc Gen is at volume 8, tab 4, and just to open it very briefly, just to get it into focus, so it's volume 8, tab 4, the Advocate General at report page 987, paras 9 to 13. And it was observed this morning, if I may say so correctly, that in its judgment the court didn't refer to the concepts in the Advocate General's 9 to 13. That said, they are extremely fundamental, as I hope just to demonstrate in 1 second. You'll see in para 11 on page 987 of the Advocate General a reference to the Reisdorf case. Just come to in a second. And you will also notice that the disposition made by the court at page 998 was wholly in line with the Advocate General's proposed disposition at 992. So I'm asserting that there's no reason to think that the court necessarily took a different view, but I can only assert that. What may be helpful, given that Reisdorf is mentioned in 11, is just to go back. Oh yes, and just before leaving the Société Générale case, with a tiny point. Société Générale case was not a case on the principal VAT directive or its predecessor, the 6th VAT directive. This is only a tiny point. It was a case on a closely related system called the 8th directive, which allows people to make cross-border input tax claims. The differences do not matter, but just know that it wasn't dealing directly with our situation. Many of those cases in para 11 of the Advocate General were cases that do deal directly with the mainstream. If I can just ask the court to jog back for a second to the previous divider, which is Reisdorf, and that's at tab 3 of bundle 8.
Yeah, I think actually, although I refer to paragraph 14 of the Advocate General, I think it's actually paragraph 13.
13?
Yeah, of the Advocate General in Société Générale, where he says that the limits for adoption of formal requirements and the interpretation of minimum requirements are intended to prevent the right of taxable persons to deduct input tax from being totally undermined.
Indeed. And what I think both these cases have in common, Reisdorf and Société Générale, is extreme and ultimately misplaced punctiliousness.
Extreme and?
Ultimately misplaced punctiliousness on the part of tax authorities.
Yeah.
No, we can't possibly accept a copy. It's a somewhat different world from the one that we're debating in this case.
Yeah.
But just going back to Reisdorf, just very briefly, the Advocate General at 18...
This is tab 3.
Tab 3, Reisdorf, and at report page 186, the Advocate General is giving a familiar description, and he says, Advocate General Finelli, the role of the invoice in the operation of that system is pivotal, and then he describes it. He can trouble you with that, and the court at report page 192 at 20 and 21 doesn't use the word pivotal, but says, obviously it repeats at 20, 22.3, and at 21 says this, Article 22.3 contains mandatory rules for the drawing up of invoices. Subpara A imposes an obligation on every taxable person, etc. So the court just stresses the mandatory nature, and I'm only troubling the court with these two, given a slight hint, probably unintentional this morning, from my lady friend that might be thought to downgrade the importance of the VAT invoice, and clearly it's very critical. I don't think that's really in dispute. That That then takes me to a comment that my lady made this morning to my learned friend, or formulating perhaps back at a submission of his own, which was his submission. This is all somewhat administrative, and it is fully accepted, very administrative. And therein lies the strength of the case for an actionable breach of statutory duty. There's no glamour here. We're not dealing with bookmakers, child protection, or anything else. We're not dealing with discretions. We're dealing with purely administrative document production. These happen to be documents which have an immensely relevant economic value, and they may or may not deal with the movement of risk, as I said a few minutes ago. But it is all dull, and therefore it's a stronger case for attaching simple, clear, and robust consequences if the system is not followed. And I think my friend and I are agreed that there's a monitoring function for HMRC, very powerful monitoring function, in terms of the production of these documents, because they are entitled, when they come on a control visit, to say of the now non-existent filing cabinets, let me see the drawer which has got all your VAT invoices in it. And if there's a very large turnover and very few VAT invoices, or worse still, suspiciously low turnover and very few VAT invoices, the system isn't working. So the commissioners themselves, that perhaps sadly not here today, one guesses would not support either any downgrading, as it were, not that this is seriously suggested, of the status of the VAT invoice, nor, just to move the point on, mindful of my learned friend's suggestions as to the non-continuing nature of the duty. So I'm leapfrogging now, but I'm staying in an area which might well be of interest to the commissioners. My learned friend was saying this morning, the duty is not continuing, it's broken on day 31 or the day after the return. And indeed, there is a breach on that day, but I'm sure that there's no risk of the court being tempted to say anything that would roll back the scope of Section 69, however collaterally it won't affect this taxpayer or these parties. But Section 69, quite plainly, and I think I quoted this in the note I handed in this morning, does see the duty as a continuing one. It
sees the failure as continuing.
It sees the failure, precisely. It sees the failure as a continuing one. But the inference I submit from that is that the duty is continuing. It may be that we're dancing on the heads of pins here, but it is one that remains in place, we say, until satisfied. You have
if you're talking about the Section 69 consequences of a continuing failure, that's one thing.
Yes.
You've got to find day by day. If you're talking about the civil law consequences of a continuing failure, having found a privately actionable duty, that's a different matter.
My lord, it is, and the state, as it were, withdraws from the arena on day 100 in terms of Section 69. It shakes its head and walks off, sadly, leaving no penalty and, query, no other mechanism.
But for every single failure to provide a VAT invoice.
Yes.
So, with a large organisation, there
Yes.
are a lot of failures in every prescribed accounting period.
Indeed, and if enforced, lots of money for the Treasury. But I don't represent the Treasury.
No.
So that was my response there. I'm unsure where, if anywhere, the question about the status of secondary legislation as diluting or not the implication, and I'm not asking, obviously, but as diluting or not the ability to imply actionable status. This is day one.
Well, it's discussed in the Hague case. Lord Jauncey discusses it.
Indeed. I'm just not quite sure how far or where it was left yesterday. It's transcript 148, 149. So my short answer is, in a case such as Todd, obviously, if mere status as a duty coming out of regulations would have been a negative factor, then Miss Justice Newberg could have saved him a lot of trouble not going through the details.
Well, I was reminded yesterday that I had to look into this in a case that is cited in one or other of your skeletons about the obligation of county courts to give notice of bankruptcy steps to the
Yes.
to I can't remember to whom.
Yes, that rings a bell.
Which I found trustee of St John Polton's, trustee in bankruptcy and Ministry of Justice,
Yes. Yes.
where we held that there's no privately actionable duty.
And the answer is in my submission that obviously in a situation such as every case turns on its own facts, of course, but in a case such as this, there is a clear unifying theme from the directives down to the VAT regulations of a once member state achieving compliance with its EU obligations in a particular manner, and given the non-discretionary nature of the underlying obligation, it's really not at all a significant negative factor that we find the specific obligation in Regulation 13, made as it is, and my lawyer friend very, very helpful. I'm extremely grateful. He pointed out the vires. No suggestion it's not that it is ultra vires. And beyond that, that's the way we do things in this country. We use primary and secondary legislation, and it's substance. We say that. A quick point before I go to issue 2. Energy solutions was debated yesterday. No reason to open it. For your note, it's volume 3, divided 2. And the observation that I would make, and I obviously have in mind the exchanges that my lord had with my learned friend, is that there you have a situation in the remedies directive context of fast-moving, multi-party commercial events where someone is saying, I didn't get a fair crack of the whip when I quoted for this lucrative state contract. The state wants quickly to sign the contract, and therefore, yes, that is, and I was quite wrong, I didn't have that in mind, I apologise. That is a situation in which the EU has said, not what cause of action to use, not primary, secondary, not tribunal, transfer division, whatever. It simply says, you've got to get this sorted out. I don't think it even uses necessarily the word judicial process, but it clearly has that in mind, in terms of hearings, a 30-day time limit for someone to make a challenge, and rapid resolution. So yes, that is one example, but it still doesn't mandate to the member state how it would achieve that, and that's obviously left to the legal and cultural traditions of the state.
Well, of course, there are different ways of doing things, but I mean, the Intellectual Property Enforcement Remedies Directive, for instance, tells member states you must require a knowing infringer to pay damages, and if he doesn't know and doesn't have reasonable grounds, didn't have reasonable grounds to believe he was infringing, then you can have an account of profits. So it spells out a whole lot of different remedies.
But the question is, again, I suppose, I've got to accept that. The question is, well, we can see why, because obviously intellectual property is ebbing and flowing through the community, and one needs to police the system. They needed to police the system at a community level. Whereas here, VAT is very much intra-member state, and it's for the member state to get on with it. Perhaps that's the simplest answer I can make there. So that takes me to issue 2. A few points remaining. My learned friend's reaction, and it may not be his final reaction, I don't know, to the note I put in this morning. He may want to come back on it. I certainly don't object if he does. But his initial reaction introduced the question of breach, or damage rather, I'm so sorry, he introduced the question of damage as somehow falsifying the approach. The answer is the approach doesn't deal with damage. The approach is only dealing with the question of what's the duty and when is it actionable. Damage may or may not occur. So
Just repeat that.
the
Actionable without damage. Is that what you're saying?
the note just deals with the question of what's the duty and when does it become actionable. In other words, the knowledge point at the second
Yes,
half.
but isn't damage part of that
Well, yes, of course it is.
as well?
Yes.
So it's not what you just said. I've written down your paper is focused on duty, when it's actionable, and damage may or may not occur.
That's what I said.
Yes.
Qualify it, Mr. Cordaro.
I need to qualify rapidly. But what I had in mind, but didn't say, was second half of my note of this morning. When would Parliament intend it to become actionable? Still going. In other words, when would Parliament move it from a purely public law matter between HMRC and a taxpayer into the arena for which we contend, where there's a horizontal right? And what the second half of the note does, I now understand my learned friend's point, forgive me, having misunderstood him. The courts had to explain it to me. But what I'm addressing in the note is, what is the feature that moves this into an area where there is political decisions to be made that one can bring horizontal claim in the courts, a private claim.
So stage one on your note regulates the position as between the supplier and HMRC.
Yes.
Until you get to stage two in your note, regulation 13 has no, well, it has effect, of course, it has no justiciable effect as between different taxable persons.
No horizontal effect.
No horizontal effect.
I'd adopt that, no horizontal effect. But of course...
And you say, stage two defines what, in a particular case, i.e. the case of reasonable excuse, when it becomes actionable, but that leaves entirely aside the question of damage, which is also necessary for it to be actionable.
And the answer is yes and yes. Save in a quiet tune.
Well, yeah.
But save for that obvious comment.
Yes.
And so only actionable in your second stage means only actionable between citizens.
The horizontal effect comment that my Lord made, and which I very gratefully adopt. So I move forward. I leave that point. I come to the question of damage days, and nearly there. This takes us into the arena of PPL, phonographic, Sefton, and Spencer. Of course, none of those cases factually, obviously enough, line up quite with ours. My learned friend took, perhaps with a lighter touch than he ought, the question of when damage was suffered. He used such phrases as worse off, and soon as we put in that first return after the non-arrival of the invoice, he says we're worse off, and one understands that. He hasn't engaged with the capital loss of use of money distinction that I made, so there's nothing for me to reply on the pristine point. It all now turns on the view you take of my learned friend's loss of the use of the money point. So it does come down to the delay, and I respond two levels. First of all, factually, there and I'm just going to say this, there's no point in developing it again, if we can show that the invoice wouldn't have been, the claim wouldn't have been paid, then there's a simple factual causation point, which obviously for today's purposes...
Sorry, you say the invoice wouldn't have been paid.
I'm so
if in
sorry.
response to the invoice, HMRC had not allowed the deduction.
Yes, or to put it better, if we can show, as a matter of fact, that had we put in the claim for input tax, armed with the tax invoice, commissioners would not have paid it for their own reasons, then we say that Royal Mail would have a complete defence as long as that lasted. Just the suggestion that they have caused my clients loss by reason of their delaying the moment when we can make our claim. So that's a purely factual point. The learned judge and my learned friend respond to that by saying, but in the fullness of time, you would have got your money. And let that be assumed. The effect of that is simply to underline my pristine point. So the capital value is never eroded. But my learned friend is not looking at that. He's going for the loss of the use of the money, as he's entitled to, of course. And he makes the point, rightly, that even if we, in due course, manage to get something from the commissioners, they won't be liable for interest prior to the moment when we make our claim holding the invoice. And that is true. So we will have lost the interest. We'll get some interest from the commissioners, but we will have lost the interest. There is a small and niggly point which I mention. Not sure it goes a long way for me, but Sefton talks about the measurable or significant, certainly measurable damage. Well, for the first few months, depending on where interest rates are at any given time, perhaps we don't have. Certainly the first week we don't have. It's 1/365 of something. But that's a niggly point that perhaps doesn't get me very far. Of greater interest, however, and the reason we included the Burney case, which I'll very briefly take you to, is simply an example. Of interest is this. This has a lot of structural resonance with want of prosecution through solicitor's negligence. I have a claim. Someone has got in my way in terms of my reaching a third party. So I have a claim, my solicitor is negligent, he or she sits on it, and we've got so many cases on this where the courts have to decide, how long did they sit on it, and how did the chances of the strikeout occur?
Possible chance.
Yes. And
Evaluate it.
Precisely. And in those cases, I can't see that anyone ever says, let's cut the Gordian knot here. You're being delayed in getting your money. Really doesn't matter whether your claim remains whole or has deteriorated to the point where you've really got to settle for peanuts.
But these are surely cases usually which you cannot make the claim because your solicitors have been negligent in failing to issue the proceedings or failing to pursue the proceedings properly. The case has been struck out always.
Indeed.
You've then got to assess the chance of whether you would have recovered, and if so, to what extent, if the solicitors hadn't acted negligently.
My lord, precisely so. And that assessment goes to the capital value of the claim. So I had the car accident, it was £20,000 worth of damages. I was either struck out or had to settle for £5,000 because I was in such a precarious procedural position because of my solicitor's delay. Now, in this case, we don't have that problem because the capital element remains whole and intact, no question of assignment or any deterioration. But a short answer in that kind of situation, or the case where they had to settle for a much lower figure, would always be, well, the solicitor, never mind about that, the solicitor's delay, 5 years, 2 years, whatever it was, has kept you out of money, whether it's 100% of the claim or ultimately the 20% that you had to settle for. And one doesn't see this short point that my learned friend is taking being taken. Now, maybe everyone's missed the point, or maybe there's a further point to be made, which is cases, all the cases, including the delay cases. I'll just open Bernie, really only for the headnote in one paragraph. Particulars of the case don't matter, it's just an example. All the cases look at the impact of the delay on the value. And you've got my submissions on that. And my submission in this context, the fact that we are, quote, kept out of the money that we will get sooner or later is not sufficient, we say, to start time running. I can't develop this point very much because I just can't find anything that really addresses it. The Burney case is, I think, in divider, in tab, in volume, and it's, I stress, it's just an example of a genre. It's volume 8, tab 6, and it's a Court of Appeal case. It's a run-of-the-mill case where there was a car crash, solicitor delays, and perhaps take a moment just to look at the all too familiar story. And much of the case is taken up about possible inconsistencies between various cases in this area. None of that matters. At the bottom of report page 448, there's a quote from Lord Justice Sheeman in Khan, just at para 33, which in a sense encapsulates the sort of debate people have in these want of prosecution cases. So if it's this very short point, I take nothing else from it, that if it was as easy as my friend suggests, and this lady suffered damage as soon as the inordinate delay began, and one looks not at the capital asset, but at the cash flow point. My very last point, subject to any questions, on Equitas, my dear friend read from that case, obviously a wildly different set of facts, and the focus of my submission always has to be on the particular nuances of the story before the court. Those are my submissions.
Thank you, Mr. Court. Right, that deals then with issues 1 and 2. So,
I think Mr. Herberg might have a right to reply on
Yes.
cases.
yes,
cited.
that's true, you do.
Lord,
I
yes,
don't know if you wish to.
Lord, I don't particularly wish to know if there's any questions the court has.
So that takes us on to your appeal, does it?
Lord, it does.
Right.
A sudden change of scene, change of law.
Should we also say that you saw this reformulated duty only this morning? I don't know if you may wish to offer us further thoughts after the short adjournment.
Lord, I would, and I'd rather not do it after the short. Well, I will. Yes, it might be that I will ask even a little longer indulgence than that. My principal solicitor isn't in court today, and
So if necessary, you can put submissions in writing.
well, I'd be very grateful. I won't do so unless there's something new or different to be said. I'd be very grateful for that indulgence.
Right. So your appeal essentially is: are we bound by UB Tiger?
Lord, yes, it is. That's the essential question, and since we're all here anyway, we thought that a cross appeal on that point was at least worth troubling Lord and Ladyship's with. It is a technical point, but we say an important one. The issue is whether the time limit provided for in Section 2 of the Limitation Act 1980, actions founded on tort, being 6 years, applies to a claim for injunctive relief, or whether that time limit is displaced by Section 36(1) of the Limitation Act.
Do you say that UB Tiger is distinguishable, or simply that it's wrong?
We say it's wrongly decided.
You don't try to distinguish.
I don't think I can distinguish it. We say it is wrongly decided. It's per incuriam and it's contrary to Sieta Seguros.
Well, you've got to say A, it's wrong, and B, it's either per incuriam or for some other reason within Bristol Aeroplane.
Lord, I do.
Separate points.
Look, they are separate points, and I'll develop the points separately. There's a technical point of distinction in that it is a case dealing with a remedy of specific performance, which is not anymore. It was once, but is no longer an issue on this appeal because the contract claim has gone. There's a technical difference.
Do you rely on that as a reason for distinguishing UB Tiger?
Well,
if you don't, fair enough. Then we are into young Bristol Aeroplanes.
Well, I struggle with a difference between conceptual purity and precedent. I submit I'd be entitled to say that it doesn't bind the court because it is dealing with a different remedy. I cannot point to any anything in the reasoning of Lord Justice Morbick that wouldn't have applied to the remedy with which we're faced here, which is an injunction. But as a technical matter of distinguishing, and particularly when one looks at the equitable cases, how often they do say, well, this is dealing with a different remedy, without there necessarily being a different theory of law attached to that different remedy. I would go so far as to say that I'd be entitled to distinguish UB Tiger. That's not a basis on which I have put it in my skeleton argument.
No.
But your Lordship is right to direct me to that question because, to be fair to me, it is a basis for distinguishing which has only, as it were, appeared since I wrote the skeleton argument, because at that stage there was at least the potential of a specific performance claim, which would be on all fours with UB Tiger, still being before this court, had the claimant succeeded in obtaining permission to appeal on the contract ground. After I filed my skeleton, that permission was refused. So that claim was gone.
Yeah.
And look,
in terms of specific performance, I might say, well, that's simply a manifestation of the principle that equity regards as done that which ought to be done. It's based on consensus between the parties.
But yes, and there are separate streams of authority in relation to specific performance going back, and there's clearly separate consideration given. It's not as if the same principles in equity are necessarily integrated there. But I accept that.
But the claim for an injunction in this case is unlike some claims for an injunction. It is in effect a claim that what ought to have been done pursuant to a statutory duty on this hypothesis actionable, the pursuit of the should be done. So it's a mandatory.
Well, it is a mandatory injunction.
Akin, though of course not in the context of contract, akin to specific performance.
Well, Lord, it is effectively. It's a mandatory injunction to perform the duty, and that is the case whether one is taking the. There are two bases for the claim for an injunction. One is breach of statutory duty domestic, and the other is breach of EU duty, which is also live and informs this appeal. But in both cases, this is effectively a mandatory injunction. But nevertheless, it is not a claim for specific performance, and there are different.
It's not
streams of authority. It's not contractual. It's not contractual. It proceeds from quite different legal rights, and I do take my Lord Justice Lewison's point that there are potentially different considerations applied to specific performance. If I can adopt that, where it's an addition. It doesn't affect the substance of the argument, but it affects effectively where this court could choose to go with the argument, which I will develop. The claim for an injunction, as I just said, now arises in respect of two separate causes of action. Breach of statutory duty, if this court finds against me on issue 1, and secondly, the claim for breach of EU law on the assumed basis that Royal Mail is an emanation of the state, which is, of course, also a tortious claim, which is still live. In other words, it's the withdrawal issue 9. Lords, if the claimants succeed on their appeal on issue 1, such that they do have a claim in tort for breach of statutory duty, but they lose their appeal in relation to whether the duty is continuing or not, issue 2, then this cross-appeal becomes one of acute significance for this litigation, because Royal Mail will have succeeded in knocking out, in time terms, vast swathes of the claim in tort, damages for breach of statutory duty, and the Frankovich claim for breach of the EU duty, going all the way back to the 1970s. The claim in damages will be limited to the 6 years preceding the issue of the claim form. However, unless Royal Mail succeeds on this cross-appeal, the claim for an injunction, in addition to damages, will mean that the advantages in terms of cutting down the scope of the litigation of that limitation defence will largely be lost. Because, under the approach of UB Tiger, the addition of the claim for an injunction, if it applies to an injunction, will keep alive those tort claims, which span back in time some 44 years, even though there's no longer the ability to reach back by way of a damages claim. And those injunctions claims are based on identical allegations of fact and law as the claims for damages, largely been knocked out, and will require a detailed factual inquiry, for example, into the negotiations which took place between Royal Mail and the claimants. Because, of course, individual negotiation is one of the few things that is really agreed coming out of the ECJ decision in TNT 1, is that the court did hold that where postal services were individually negotiated between Royal Mail and someone receiving services, then we are outside. We are outside any exemption that is attributable. So the individual negotiation test is the one bit of the law that is agreed, and there is claimants have pleaded, not accepted by Royal Mail, that there was individual negotiation into a variety, not all, but a variety of their services. So that issue would have to be potentially looked at going back 44 years, just for the purposes of the injunction claims. If the claimants fail on their issue 1 appeal, the issue that your lordships and your ladyship have heard yesterday and today, then this cross appeal will obviously cease to have significance for the statutory duty claim, because that will no longer exist. In other words, issue 5 will go. The specific performance claim based on contract has already gone, but in any event, this cross appeal remains live in respect of issue 14, the EU claim.
14.
Issue 14, my lord, is the list of issues is in the judgment, paragraph 31. If your lordship wishes to remind me, I was going to do that. It's quite a long list. So issue
Oh, yes, I see.
14 is...
Yes, I see.
Yeah. My lords, my lady, we say that UB Tiger was wrongly decided, if we need to. The court purported to follow, and importantly thought it was following, the approach to section 36 adopted in the preceding Court of Appeal decision, Cia de Seguros, but it misunderstood, we say, that approach, and instead adopted a very different interpretation of the application of section 36. And so we say, if we need to, that UB Tiger is therefore in conflict with Cia de Seguros, and it is for this court to choose between them. But I should make plain, by way of preliminary, having considered the claimant's skeleton argument and the Iqbal case which they cite, we are content to rely principally on the first exception of Bristol aeroplane, and also in addition the third, that is per incuriam. But we will not rely on the second exception, cannot stand with a potentially subsequent decision of the House of Lords. We said a decision of the House of Lords. We won't seek to persuade the court, contrary to our skeleton argument of paragraph 51, which does refer to and seek to rely on the second exception, that UB Tiger can be overruled simply by reason of an inconsistency with the earlier decision of the House of Lords in Knox and Guy. So we won't take that line. We do say that Knox and Guy is relevant to the court because it comes into some of the later decisions and needs to be is looked at there. We're not going to rely on...
The first exception is conflicting authorities. The third is per incuriam.
Lord, yes. Lord, yes.
Yeah.
Well, that might be a convenient... I was going to launch into section 36 and make some initial
Yes,
observations.
fine. I do remember a case in which it was said by this court that a previous Court of Appeal decision had misunderstood an earlier one. It was a case that I was in, actually, as counsel. It's a case called Starmark Enterprises, and I've forgotten the name of the other party. CPL, maybe? Something like that.
I'm grateful, Honourable. I hope the outcome was that the court was prepared to relook at the decision of the
It was,
subsequent case.
rather to my surprise.
Well, Lord, I'm very grateful. Not surprised, of course, but I'm grateful for that, and we'll have a look at that.
Right, 2 o'clock.
Thanks, Bob.